Today we will be covering the 1 to 4 family residential contract that the Texas Real Estate Commission came out with in November of 2020. It is required to be used as of April 1st, 2021. So let's get right into it. So I'm going to share my screen and I will be talking about each paragraph. Now, mind you, this is pretty lengthy, but it will cover 99.9% of your questions, okay? So page 1, we have the parties of the contract are, the seller goes in the first blank, buyer goes in the second. Property, it is defined as the lot, block, subdivision, and city in the county of, and also known as this address. We have both the legal address and or description and the street address listed because the street address can change, okay? But legal description doesn't. Improvements, anything that's permanently attached to the house. So for example, anything that's permanently installed to include built-ins, appliances, ballasts, screens, shutters, awnings, wall-to-wall carpeting, mirrors, etc. Okay, anything that's basically built-in. Now, if it's nailed down built-in, it's growing out of the ground on the property, it stays, okay? Any outdoor equipment that's attached to the property, if it's hard plumbed into the house. Accessories, anything like AC units that are window units, stove. We commonly see that realtors will add stove in either another place in this contract or in the non-realty items addendum. That's actually incorrect. If we add something that's already mentioned in a contract, we are basically practicing law. We are not allowed to do that. So stove automatically goes with the property. Fireplace screens that are specially made for the house, pool equipment, anything specialized, controls, mailbox keys. Now, if there was anything that the seller is going to specifically keep, we would list it here in paragraph D. This also says that any reservation for oil, gas, or minerals, timber, other things, if there's anything that's on the property, such as those things, we would have to make sure that we put it in a separate form if it's something that the seller will keep, okay? Or that does get conveyed to the buyer. For example, if you have oil that you're pumping out of the ground, we would have to make sure that that conveys. In El Paso, that is usually not the case. We don't deal with those issues, but these contracts are for the entire state of Texas. Sales price. So sales price consists of two things, down payment and loan amount. Down payment goes in this first spot. Loan amount goes in the second spot. So when you add A plus B, it should always equal C. C is the price that the buyer is actually offering. If the buyer winds up getting a loan for the mortgage, that would be third-party financing. If they assume the current mortgage, take over the current mortgage, it would be this. Or if the seller owns the house free and clear or the property free and clear, and they are acting as the lender and taking payments, it would be seller financing. Leases. This applies if the house is being rented out. So even if the house is being rented out, the tenant would convey with the property if they're still, if they haven't been given notice or they still have a lease that hasn't ended. So if that's the case, then the seller would provide a copy of the existing leases, and things like security deposits would have to transfer with it as well. If there's any fixtures, leases, for example, if they have solar panels, which are a lot more common, those usually aren't owned, those are leased. So those, we have to make sure that we provide the separate form for that, and that the buyer understands that those are being conveyed and that they are responsible. Or something like a security system, like the ring system, if there's a current lease or Vivint or whatever. If that's something that has to convey with the property, we have to disclose it and we have to make sure that's in there. If there's any existing oil or gas, mineral, water, wind, other natural resources, we also have to convey that. Again, we don't deal with that in El Paso a whole lot. So this says either the seller has delivered a copy of those natural leases, resource leases, or they will within how many days? Within 3 days. And if not, the buyer can contract terminate within so many days after they receive that, okay? So that is negotiable. Page 2 talks about earnest money and option money. So what's earnest money? Earnest money is consideration for the contract. It basically, kind of gives the contract teeth. So it shows that the buyer is putting skin in the game. So within 3 days, not business days, not holidays, 3 days after the effective date of the contract, buyer must deliver to whatever title company is as escrow agent at whatever address this much earnest money. So that's all negotiable, which title company they use and how much earnest money. And also the option fee, which is this box right here. So the option fee is the amount of money that the buyer pays to the seller for the unrestricted right to cancel. If they want an option period, that gives them the ability to negotiate during the first few days of the contract for repairs or whatever they want, they must pay for that. Okay. Now, if they cancel, they don't get it back. If they stay throughout all the way to closing and do purchase the property, then it's a credit to them at closing. Okay. A buyer shall deliver additional earnest money. If you negotiate for additional earnest money, we would put it in there. Now, this explains that if the last day of the earnest for them to deliver earnest, an option, or additional falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money, option fee, or other additional earnest money as applicable is extended until the next day that is not Saturday, Sunday, or a legal holiday. So let's say day 3 is Sunday, then they automatically have until Monday to turn that in. Okay. This also says that the amount that the title company receives shall be applied first to the option and then to the earnest. So that's why it's extremely important to send all those monies at once. For example, let's say you have $100 for your option period and you have $1,000 of earnest money, but the buyer only sends in $1,000. Well, 100 of that will be applied to the option fee, and the remaining 900 will be applied to the earnest money. And guess what? The buyer has not deposited the full earnest money. So this basically says, for nominal consideration of the receipt which seller acknowledges and the buyer agrees to pay the option fee within the time required, seller grants buyer the unrestricted right to terminate of the contract by giving notice to the seller within so many days. For example, if we date a contract on Friday and we have 5 days for option, Saturday is day 1, Sunday, Monday, Tuesday, Wednesday at 5 p.m. in the time zone where the home is located is when your termination option ends. So if the buyer is going to terminate, they must do it within those 5 days by 5 p.m. on the 5th day. Now, if the buyer gives notice within the time prescribed, the option will not be refunded, and the escrow agent shall release any option fee remaining with the escrow to the seller. That usually is not the case. And the earnest money will also be refunded to the buyer. Failure to deliver earnest money. If the buyer fails to deliver the earnest money within the time required, the 3 days, the seller can terminate or exercise the remedies under paragraph 15. So basically they can sue or they can take the earnest money, but they can't do both. So it's extremely important that the buyer deposit that money within that time, because if they don't, day 4, the seller sends the notice, I am terminating, it's game over. Now, if the seller does not send in the notification on day 4 and the buyer does send in that earnest money and the title company receives it, then it's been delivered. The seller no longer has a right to terminate, okay, for that reason. Failure to deliver option fee. If there's no option fee delivered, there is no option period. The buyer does not have the right to terminate. That's why time is of the essence. It's very important to comply with these timelines. Title policy and survey. Seller shall furnish to the buyer at either seller or buyer's expense an owner policy of title insurance by whatever title company is here, in the amount of the sales price dated on or after closing, issuing buyer against the loss of provisions of title. Subject, of course, to the promulgated exclusions included in existing building and zoning ordinances and the following exceptions. What does that mean? That means whatever box is checked means that party will pay for the title insurance. The title insurance makes sure that when the buyer becomes the owner, that there will be no other people coming back after the fact saying that I'm actually the owner, or I'm going to place a lien because the previous owner didn't pay for the pool, or I did plumbing work for the previous owner and now they didn't pay me and I'm going to file a judgment against you. That covers the buyer. Or an heir coming back and saying, I was part owner of this property and I was cut out of my portion. Okay. It's things like that that cover title insurance. Some of the things that are not covered in there, title will not step in and have coverage, is restrictive covenants. So when the property was developed within that subdivision, there was a general list of rules for the way the people in that subdivision can expand, do certain things with the property. So for example, in an area where you have nothing but large homes, I'm sure that the builder and the developer said, in this area, no homes will be built under 2,000 square feet, okay? So things like that are not covered. So if that is a concern about, regarding what can be done in that subdivision, it's very important to talk to me as your realtor or the other party if you are representing the other party in the transaction. Standby fees, taxes. If the owner doesn't pay taxes, they can be foreclosed on, and title insurance will not cover you. Any liens that you get on the property, based on paragraph 3. So if you get a loan and you don't pay the loan, they will foreclose on you and title will not cover you. Utility easements. Utility easements are lines of utility that run either in front or behind the property. Basically, if there's any utility lines, the survey should show. If you build like a big pool on top of a utility easement in the back, the title company and the title insurance will not cover you. Any reservations, any special things that you may put in this contract, and won't cover marital rights. So if you have a couple that's married and they purchase the home and they get divorced and one party wants the house and the other party wants the house, title insurance doesn't cover you. Other things that really don't apply in El Paso, like tide waters, beaches, streams, things that can wash away part of your lot or flood it. Title insurance doesn't cover that. Or any other kind of shortages that show up on the survey, okay? That's something that is disclosed right up front. So if you want the extra coverage and shortages in area, you can either check for the buyer or the seller to pay for it. It's not very expensive. And then of course, accept or exclusion regarding minerals. So usually at title, the title company will have the party sign, the buyer sign and say, if there's any valuable minerals found underneath the property, it does not belong to you. It belongs to the state of Texas. It's a Texas thing. Commitment. The title commitment is like a summary that the title company pulls as far as everything that they see regarding the property. Any kind of liens against the property, any kind of issues, things like that. There's going to be different schedules, and normally we focus on Schedule C, but it's important to look at everything, right? So within 20 days after the title company receives the contract, the seller shall furnish to the buyer a commitment for title. Then at buyer's expense, legible copies of restrictive covenants and documents. Let's see, to the commitment company to deliver the commitment and exception documents to the buyer at buyer's address shown in paragraph 21. I usually put my address there, so that way any information they need to get to me, I will convey to the buyer, or they need to get to the buyer will be done through me so I can ensure that they get it. If they are not delivered within that time, the time will be automatically extended another 15 days or 3 days before closing, whichever is earlier. So title doesn't get that out to buyer within 20 days, they get another 15 or up to 3 days before closing. Now, if the commitment and exception documents aren't delivered to the buyer within that time, the buyer can cancel and they will get their earnest money back. Survey. The survey must be acceptable to the title company and the lender, okay? So this checks who provides it and who pays for it. This paragraph has this is my template, so I automatically put this in for my buyers, that within 10 days after this contract, seller shall furnish the buyer an existing survey. And the T47, basically it's a form saying that they've made no significant changes to the survey, like a pool or adding rooms. Now, if the seller doesn't provide one or the other, then the buyer can obtain a new one at the seller's expense no later than 3 days prior to closing. So if the seller has a survey, it's very important that they get that out within the time that's in here, if this box is checked. If they don't and they wait one extra day and the buyer's agent has ordered a new survey, well, guess what? It says here that the seller has to pay for it, okay? Now, and this is what I have checked off. Now, if the seller cannot find a survey and this box is checked where the buyer's expense, then either the money that's due is automatically going to be on the buyer for the survey fee. Now, let's say the buyer just wants a whole new survey. They can do it at their expense there, or the buyer or the seller wants to provide a whole new survey at their seller's expense. We would check that. Objections. Buyer must make in writing to defects, exceptions, encumbrances to title disclosed on the survey other than 6A, which is the title, right? Except these, that's not covered. Sorry about this little windows popping up. And through 7 above, disclosing the commitment other than those items or which prohibit the following use. So it's already a given because we're using a residential contract that they're going to use it for that. But if there was anything special that the buyer wants to do, like they want to ensure they can put a pool on there, or they have to be able to park their RV, or they can have goats or whatever, or they can run an adult daycare out of there, that's what would be entered here. Now, buyer must object the earlier of the closing date or 5 days after they get the commitment and the survey. If they don't object within that time, that means they're waiving their right to object, except that the requirements in Schedule C are not waived. That's like if there's an IRS lien or something held against the property, okay? So provided seller is not obligated to incur any expense, they shall cure it within a timely fashion or any third-party lender within 15 days, okay? After they get the objections to cure that. Now, and the closing date will be extended if needed. Now, if there's something, an objection, they put it in writing before the 5, for example, the 5 days in this situation, and they have the 5 days and they, they cured it and it goes past that closing date, then the closing date gets extended. If they're not, then buyer may, by delivering notice to the seller within 5 days after that 15-day cure period, terminate the contract, and the earnest money will be refunded to the buyer. So you get the title commitment. From that day, you have 5 days to put in writing any objections to have. Let's say you wait until the 4th day. Then at the 4th day, the seller that you notify the seller, he's got 15 days to fix it. At the end of the 15 days, you have 5 days to let them know that you will be terminating. So there's a lot of little nuances in here. For the most part, we don't see those issues happen, but they're in there for a reason. Title insurance, abstract of title. Every buyer has a right to get an abstract of title. That is where the buyer hires their attorney to look at the history and the chain of ownership for the property. So basically, you want to, if it's like a ranch where it was passed down from one generation to another, is usually where a buyer will be more inclined to want to get this abstract. But any buyer can get an abstract for any property at their choice. And, we're required to disclose that. So membership of an HOA. If the house is in an HOA, then we would check yes. If it is not, then we would check this not subject. Now, this is important information because they must get a list of the rules, the information from the owners association, the restrictions, because if they don't pay the HOA fees, they can be foreclosed on. Okay, you are obligated to pay assessments to the property or get foreclosed on the property. Also, you have to get the information for the establishment, maintenance, and operation of the subdivision, bylaws, rules. There will be a resale certificate. There's usually a fee involved, so you have to determine who's going to pay for that fee, and there is a separate form So if it isn't an HOA, we have to add that form in here. Well, along with this contract. Now, if buyer is concerned about these matters, we have that special form called the Addendum for Property Subject to Mandatory Membership in a Property Owners Association, okay? Now, if there's any kind of special tax district, then we have to make sure that we provide that information to the buyer. I have never dealt with any in El Paso. I'm not even sure if we have any, but if that applies, we would have to provide the information. Tidewater is another thing we don't see. If it was beachfront property like Galveston, where you have a beach, you have to make sure you provide the information for that, because some of the water on your property can be washed away, right? Some of the water, some of the soil and your land can be washed away. Now, if the property is outside the city limits, you have to be aware that at some point in the future, it can be annexed. It can be included in the city limits, okay, or municipality, and then you would have to follow that city's rules, right? But again, I don't deal with that a whole lot, usually not an issue. Property located in a certificated service area of utility service provider. So if there was a special service provider that was in that area, we have to provide the information for it, okay? There may be special costs involved in those, so it's important to always make sure that you check and that you ask if that's a concern. Public improvement district, again, if there's some kind of special project going on where there's charging special taxes or fees, we have to disclose it. Transfer fees. Transfer fees we usually don't see unless it's like a condo or it's in an HOA. Those are the kind of fees. And of course, we do have to provide that information. If there's a special propane gas system, we usually don't deal with that either, where it's a service area that has the distribution system and they're the retailer for that. Notice of water level fluctuations. If you were near a lake, a reservoir, and it was constructed and maintained under Chapter 11, the Water Code, that has a storage capacity of at least 5,000 acre feet of the impounded normal operating level. Basically, it's saying a big body of water, right? We have to let you know because there's always a possibility of the water going very low, affecting your property, or going over and flooding your property. Again, not something we deal with in El Paso. We are in the desert, okay? Property condition. Okay, so the seller has to have utilities on for the buyer to do the inspection, okay? And it's at the seller's expense, not the buyer's, okay? And to keep them on during the time of this contract is in effect. And the reason is appraisal happens still, the appraiser needs those on. Buyer can do a final walkthrough. They want to check to make sure there's no water leaks. That's what they do that for. Now, seller's disclosure. Texas Property Code requires that the seller disclose anything they know about the property. So if it was foreclosure, sellers, the bank that has foreclosed and owns the property is not required to disclose. If it was an inheritance, if it was something from an estate, you're not required to disclose. Now, if it's a married couple and the title is being transferred from the husband to the wife in a divorce, again, okay? So those are the situations where you don't have to do that. Otherwise, you do. Now, if the buyer has received the notice, then we check that. Usually it's attached in the MLS. If they have not received the notice, we're asking them for delivery within this time. If they do not receive the seller's disclosure within that time, the buyer has a right to terminate and get their earnest money back. Now, if the seller delivers it, buyer can still terminate the contract for any reason within 7 days after they receive it, or prior to the closing, whichever happens first. So it's extremely important that we get a copy of that or we provide one, and that the earnest money will be refunded to the buyer. Now, if the seller was not required to, then we would check this box. If the house was built 1978 or prior, there's probably lead-based paint under all those layers. So it's very important that we include that form. It's a federal form and it's required. Buyer, I usually send my buyers a pamphlet for lead-based paint as well. And I believe I have a video for that too, but basically it's not an airborne thing. You have to consume or digest the lead-based paint in order to get lead-based paint poisoning. I am not an expert, so it's very important that you read that pamphlet. Now, acceptance of property condition as is. So basically for now, the buyer is saying, I will take it as is if they check this. If they check the number 2, they're saying they're taking it as is, as long as whatever treatments are in here or repairs are done. Now, for the most part, a buyer doesn't know what's going on with the property because it hasn't been inspected, okay? Unless there's a previous inspection, the buyer can still get their own. However, this says that you're taking the property as is, right? Now, even though they say as is, it does not keep the buyer from using the termination option if they have one. They can still get inspections, they can still negotiate repairs, they can still write up an amendment, or they can still terminate during that time, okay? So this is the biggest question that I see overall when I explain the contract, right? Now, let's say we get a contract, we get inspections, we negotiate repairs, the lender orders the appraisal, the appraiser goes out there and he inspects the property. And I say inspect loosely because they just go and take a very general glance. They don't inspect the property like the home inspector would. They go to inspect for value and safety. So they go out there and they say, I need XYZ done. And it was not something that you've already negotiated for during the option. Well, neither the seller nor the buyer are obligated. Somebody has to agree to do them. And if nobody agrees to do them, then the buyer has a right to cancel and get their earnest money back. Now, if those repairs are automatically 5% or more of the sales price, the buyer still has a right to cancel, okay? So, I don't know why that thing keeps showing up. Completions of repairs and treatments. So this says that unless otherwise agreed in writing, seller shall complete all repairs and treatments prior to closing. All permits must be obtained and repairs and treatments must be done with people who are licensed to provide repairs and treatments, or if they're not licensed, who are commercially engaged in trade, providing such repairs and treatments. So if you hire somebody to paint and they don't have a license to paint and they're a general contractor, they still have to be licensed as a general contractor. At buyer's election, any transferable warranties received by the seller with respect to their repairs and treatments prior to closing, okay? So if there's a warranty, the seller has to provide that warranty to the buyer. Not all contractors allow the warranty to transfer to the new buyer or the new owner. So it's very important to ask that up front. If the seller fails to comply with any of the agreed repairs, buyer may exercise the remedies in paragraph 15. So terminate and get earnest money back or sue. And not do both, or extend another 5 days if necessary for the seller to finish. Environmental matters. If buyers are worried about presence of wetlands, toxic substances, including asbestos, waste, anything in the environment that provides a threat or endangered species or its habitat may be affected, buyer intended to use the property. If the buyer is concerned about these matters, they may use the addendum promulgated by TREC or required by the parties should be used. So there's a special form for that. Residential service contract, that we call that the home warranty. Okay, so this says that buyer may purchase it and they can also request that the seller reimburse them for it here, okay? So if the buyer should make sure that they review what the scope of coverage is and exclusions and limitations. Now, the purchase of a residential contract is optional, right? So let's say the buyer wants to order it and wants the seller to pay and the seller agrees. It must be done prior to closing and we must ensure that it gets ordered. Because if we get to closing and it wasn't ordered and we fund, then it's going to be very difficult to have the seller come back because this says that the buyer will purchase it and the seller will reimburse. If the buyer did not purchase it, then there's not prior to closing, then it's very hard to enforce that. But brokers and sales agents, broker or sales agent's disclosure. This says that if either the seller or the buyer has a 10% interest in the property being sold, it must be disclosed here. Okay. If the owner is a realtor, they must disclose. If the buyer is a realtor, they must disclose. Now, broker's fees. This basically says that all obligations of the parties are in a separate agreement. So the way the commissions get paid, closing happen on or before this date. We can always close sooner, or within 7 days after objections are made in paragraph 60, which is the title stuff, whichever date is later. If either party fails to comply with the sale, the closing date, fails to close the sale by that closing date, then the party that is not in default may exercise the remedies again. They can terminate and sue, or they can get their earnest money back, but they cannot do both. Once they get earnest money, that's it. They cannot go back and sue. So at closing, seller shall execute any warranty deed, convey title to buyer, and showing no additional exceptions for those, furnish tax statements, certificates, anything that's due. Buyer shall pay in good funds to the acceptable to the title company monies that that are due. Seller and buyer shall execute and deliver any notice to statements, affidavits, loans, all that information will be signed, delivered, and executed. There will be no liens on the property except for like the loan that the buyer got, right? So possession, this is a very important paragraph. This says that seller shall deliver to the buyer possession of the property in its current condition. So it's got to be basically in the same condition that it was when they looked at it, of course, with the normal wear and tear. Now, it will, most of the time I will check upon closing and funding. That means that all parties sign, all original documents are back at title. Lender has received copies of that to ensure everything is good, and they send out the wire. If we have out-of-town parties, originals have to be sent back. And if the lender sends a wire out pretty late in the day, it probably won't be received at title until the next business day. So it's very important not to schedule all these things, the mover and everything, to be sitting outside of title when a buyer goes to close, because they probably will not get keys at that moment. Make sure that you consult with your insurance company as well to make sure what your coverages are and when they start. And if the buyer does move in before closing, we must make sure we have a temporary lease to protect all parties. Smart devices, if you have, let's say, a Nest or a Ring system, those convey. And the seller also agrees to give them all the codes, the username, passwords, and they agree to remove all that information off of their phone or their computer or other personal devices. Special provisions. If there's any special provisions, anything out of the ordinary that's not already listed in here, then the buyer would enter it here. Settlement and other expenses. This outlines who is responsible for what fees. So this says the seller's expenses, release of existing liens, prepayment penalties, recording, release of seller's loan liability, tax statements or certificates, preparation of deed, 1/2 of escrow, the other expenses paid that are outlined. Now, if the buyer is requesting that the seller pay part of their closing costs or all of them, we would have that specific amount here. Then this lists the order in which it says also there are certain fees that the seller is not allowed to pay for, or that the buyer is not allowed to pay for, it depending on whether it's an FHA or VA loan, right? So expenses by the buyer, here's the list: appraisal, loan, any kind of fees that are associated with the getting the loan up front, okay? And escrows, money that's put away for prorated interest or taxes or insurance. Amortization schedules, 1/2 of the escrow fees with title, all hazard insurance, deposits, things that we just mentioned, and also any kind of courier fees, private mortgage insurance, that sort of thing. If any of these expenses, if any expense exceeds the amount expressed in the contract for such expense to be paid for by a party, then that party may terminate this contract unless the other party agrees to pay. So buyer may not pay charges and fees expressly prohibited by FHA or Texas Land Board or VA. Taxes, prorated taxes. So seller's responsible for taxes up to the day of closing. Title company will usually get the prorated amount from the seller's proceeds and give that to the buyer. Their lender will put it in an escrow account so that at the end of the year, they will have the full year's worth of taxes and they get paid. Okay. Now, if taxes are not paid at a prior closing, buyer shall pay taxes for the current year. Well, that just basically says that the buyer will pay full year's worth of taxes. It doesn't matter because they're getting the credit from the seller anyway. Okay, casualty loss. If something happens to the house before closing, the seller shall restore it to its previous condition as soon as reasonably possible. But in the event that, in any event, by the closing date, if the seller fails to do so, to factors beyond his control, buyer may terminate and get the earnest money back, or extend the time for performance up to 15 days, and the closing date will be extended. Now, the buyer can also accept the property in its damaged condition if they get the seller's insurance company to assign the proceeds to them, if it's allowed. Now, or they receive a credit and also receive a credit for the amount of the deductible, right? So let's say it's a $10,000 claim. The seller's deductible is $1,500. The title company will get that $1,500 and give it to the buyer as a credit. And then if the insurance company is okay, they will assign the remaining amount, the $8,500 for repairs, to the new owner. But we must make sure that's all put in writing and done ahead of time. Okay. All right. Default: if the buyer fails to comply with the contract, the buyer is in default, and the seller may either take them to court or terminate and get the earnest money. But they can't do both. They do either one or the other. If they get the earnest money back, they can't sue. And it goes the other way around. If the seller fails to comply with the contract, they may either sue or terminate and get the earnest money back. Once they get the earnest money back, they release both parties from the contract. Mediation, Texas encourages it because it's cheaper and it's faster in the case that there is a dispute. And if you do wind up going to court, because you still have that right, the seller may have to pay the winner's attorney. The loser may have to pay the winner's attorney's fees. Okay. Escrow. Escrow is the title company. It says that they are not a party to the contract. They cannot enforce performance. They're not liable for any interest accrued on the earnest money, loss of any earnest money because of the failure of any financial institution where they deposited the money. Or escrow agent may also require any disbursement in connection with this as a collection of good funds. So basically, they're Switzerland. They're a neutral party. So at closing, the earnest money will be applied first to the down payment and then to the buyer's closing costs. Any money that's left over will be refunded. If there's no closing costs, escrow may require written release of liability from the escrow agent from all parties and require the payment of unpaid expenses. So let's say the contract falls through. The buyer wants the earnest money, but the buyer ordered a survey, and the seller and the title company has that survey invoice. Well, the title company will go ahead and take that earnest money, deduct it by the amount of the survey, and refund the difference to the buyer if it was the buyer's expense. So then demand. If there is a termination of contract, either party may send a release of earnest money to the other party, and all parties shall execute of the same release and deliver to the escrow. So seller wants it, they cancel, seller wants the earnest money, buyer signs off, title company will release it. If either party fails to execute the release, either party may make a written demand for the earnest money. If only one party makes a written demand, say seller wants the earnest money, buyer does not respond, the title company will send it to the buyer, and if they don't hear from the buyer in 15 days, they may distribute the earnest money to minus any unpaid expenses incurred by that party to the party requesting it. Okay. So, and then once they release the earnest money, that's it. They are not responsible for anything else after that. Any party who wrongfully fails to sign a release within 7 days of receipt of the request will be liable to the other party for damages in the case they go to court. Okay. Damages, earnest money, attorney fees, that sort of thing. Notifications are effective when sent in compliance with paragraph 21. So that the paragraph that I'll show you in a second shows where all notifications must be sent. And unless prohibited by a written agreement, seller may continue to show the property and negotiate a backup. Okay. Seller federal tax requirement. If the seller is a foreign person, as defined by the IRS, and seller fails to deliver an affidavit or certificate of non-foreign status to the buyer that the seller is not a foreign national or foreign person, then the buyer shall withhold from the sales proceeds an amount sufficient to comply with applicable law. So if the seller's of a foreign national, sorry about that, it's extremely important that they disclose that, okay? That's part of probably one of the things that title will discover as well. So I put this in here because this is my buyer contract. So any notifications to my buyer will be done through me. And then if there's any additional items attached to this contract, we list it here. For the most part, the most common items are here, which is third-party financing. For an older home, it would be lead-based paint. If they wanted the fridge or patio furniture or anything like that, then we would check this and enter non-realty items, okay? Now, if it's a conventional loan and we want to ensure that the house appraises, then we would use the, where is it? It would be here, addendum concerning right to terminate due to lender's appraisal. That's only if it's conventional, because the form at the top says not to be used for FHA or VA, okay? Buyer has a right to, buyer or seller has a right to consult with an attorney before signing anything. So, and we are not allowed to give legal advice. So read this contract carefully. If you want to talk to an attorney, you can. And if you have an attorney you want to fill out, we would put it in here if you're the buyer or the seller, okay? So that's where the signatures are. Once this comes back, agreed by everybody, initialed by everybody, then we would execute it there, not before. This shows who is involved as far as realtors in the transaction. If I were the buyer's agent and only the buyer's agent, I would check that. And if I was the seller's agent, then I would fill it out here and click that it's the seller's agent. Now, if in the chance that we wind up doing a deal where both agents work with the same company, then we would do intermediary, because the broker is the intermediary and the broker is the person that's assigned to that company. The broker cannot give information in either direction that's confidential, and they have to also, they basically can't take sides, okay? So this explains how the buyer or the buyer's agent gets paid, and it's usually off of the seller's commission. That's usually how it's done, but it's completely negotiable. And then these pages just basically are receipt pages where we can enter that earnest money and option money were received. So this is the new contract as of enforceable as of April 1st, 2021. If you have any questions about this form, feel free to let me know, and I will talk to you soon. Bye-bye. Little reminder that my business is based on referrals. Without wonderful people such as yourself, I could not keep my business running. So if you happen to know of anybody, friend, family, coworker, neighbor that is interested in buying, selling, or investing in real estate, I would love to give them the best level of personal care. Thanks so much. Feel free to reach out, text, email, or call me. Thanks. Bye-bye.